Chief Judge Lippman posed a number of questions that all go to the issue of why we have this disparity or this lagging numerical representation. And I think the answer, unfortunately, to that set of questions is really all of the above. There do continue to be social forces, some of them good social forces, some not as good, that operate to have women have to multitask at many points in their lives, so that we will, I think, see for as long as those social forces are operating that it will be a challenge to have fully equal representation by the bar in major commercial litigations. That's not to say we can't make major progress. The causes include some pressure from clients, I think, and we'll hear from some of the representatives of clients and the choices that they make. Unfortunately, sometimes clients do drive who gets to appear in court and have a big argument from the law firms. Law firms certainly play a role and have a great role to play, just like on the client side. There's a great effort underway and has been for many years to remedy the disparity by trying to deal with some of the social forces, family obligations and the like, and to truly approach staffing decisions on big cases in a meritocratic manner. And those efforts, I think, are paying off. We do see great improvements, but these things do take time. It's wonderful that the bench has evolved so very much and that the numbers are changing on the bench. That, I think, can only help to accelerate greatly everybody's effort to address the bench with lawyers who the bench wants to see and wants to hear from. So that is part of why this occasion is so very important. I would share with you just one anecdote from my experience that I think illustrates why the bench is so important in this regard. I appeared about a decade ago for the very first day of an absolutely enormous securities litigation. Every firm in the city practically was represented, both on the plaintiff side and the defense side. It was a historic litigation, and it lasted a decade. It's actually still going on. And it was in federal court before a woman judge, who I will not name just in case she wouldn't want it repeated. But she said on the very first day that we all appeared for that litigation, hundreds of lawyers gathered, very simple words as she welcomed us. She said, "How nice to see some women at counsel's table." For the next decade, for every motion and every conference, no matter how big or how small, there was at least a woman at counsel's table. I was lucky enough to be one of those women, and there were others who got an opportunity to argue big cases and the like because of those simple words on that one day. So thank you to that judge, thank you to these judges. We have a distance to travel, but we're clearly on our way.
Thank you very much. Our next presenter will be Michele Coleman Mayes.
I've tried to figure out what was good about getting older. And one thing I've decided is it somewhat frees you to say things that you wouldn't say when you were younger, so here goes. I think there are a lot of reasons why the progress we've made has been glacial, big iceberg, in fact. On the other hand, I do believe that some people will tell you, well, in the long run, the demographics will catch up. And my response to that answer to that remark is, and in the long run, you know how that goes, we're all dead. And so I've decided that one of the reasons the demographics in the courtroom and the photographs around this room sometimes get in the way because of what I call not implicit bias or unconscious bias, but unexamined bias. We've all got biases, and unless you're willing to probe and figure out where they are, you're very comfortable carrying them around with you. In fact, they become good friends. And so what I tell people when they want to look at the things like why aren't there more women in major cases or general counsels is that you need to do a couple things. And these are not panaceas, but they work for me. And I call it DVI. It's not a disease. The D stands for being deliberate. I have found that if you do not focus on this, it does not happen. And while people will say, well, it's a natural course of events because if enough women graduate from law school, I'm not buying that. And so when I say be deliberate, I mean you are very purposeful. When you look around the room, for example, when you have a slate of candidates and it's all white males, there's nothing wrong with asking, and why do you think that's the case? The other letter in that V is that you've got to be versatile. And I say versatile because you can't try one thing to fix a problem that is as old as this one. And in fact, many times you become very weary. We call it diversity fatigue, in fact. And so when I talk about versatility, I have come to understand that everybody has a different on-ramp. And you've got to understand where that person is getting on and why, what the baggage is they are bringing with them, and how do you, therefore, address it. The I stands for inclusion. And the reason I say inclusion and not diversity is for the following reason. We all have biases. I said that a few minutes ago, and if you don't believe it, go onto the website for implicit bias and find out how much bias you've got. It will make you nauseous. And so when I talk about inclusion, it's more than diversity, because diversity is getting people in the room. Inclusion is hearing their voices. And that is a big, big difference. And so I'll tell you a story that somewhat wraps this all together with a very, very large case that I had when I was a general counsel at Pitney Bowes. And the reason this case is illustrative is, number one, it was an intellectual property case. Heavy-duty patents. Would you like to know how many women are in the patent bar? I won't say it's like hen's teeth, but it's damn close. And so it was a very big case, millions of dollars brought against Pitney Bowes by a Japanese company in state court in New Jersey. And the final result is that we could not settle it. And so the case was going to have to go to trial before a jury. And the plaintiffs were absolutely filled with their all-white males, lined up in a row. One female who ran around handing them documents. Could I make this up? So when our firm came in and said, because I went to court a couple times to watch the motion practice to see who the judge was. Our firm was all female, one male. And the reason I point that out is because it was very heavily tied to a mechanical patent, electrical patent, so we're not talking about simple ideas. Things that girls aren't good at science and math, right? So when we went to trial, we had to go in and talk to the CEO because we didn't know if this would turn out well. There are no guarantees when you go in front of a jury, as all these judges can tell you. And so when we came into the room to explain that we were going to go the distance to verdict, the male partner couldn't come. I don't know where he was. The female partner showed up. And my boss said, he looked around the room a little stunned. He said, "Where is so-and-so?" I said, "Well, you don't really need him. One partner's enough, and this one will do." And when I said that, he caught himself. He said, "You're right." He said, "Go ahead, Ms. So-and-so, and present how you think the case is going to go into the jury." The long and the short of it is we went to verdict with 3 women at counsel table, and I teased the male and said he was a token. People would have said, a jury's not going to go with 3, and they were young women. These are women in their 40s. The male was 60, bald. And so I watched the jury very, very carefully. And this was the interesting thing, that even though this was a highly technical scientific case, the jury listened more intently when the female presented than when the male did. Your bias would have said a male should try this case. And so I watched that play out in that courtroom, and I said to myself, I would have probably thought this was a bad lineup, but I went with it. In the long run, you know how the story ended, or I wouldn't be telling it. And so I am not that slow. And so in the end, the verdict was entered in our favor, but I was more interested in the dynamics in the courtroom and the baggage that I carried that said, you know what, this wasn't stupid. And this was a very competent group of lawyers who tried this case to verdict. So I come back to you and I say, you need to be deliberate, you need to be inclusive, you need to be versatile, and that's the only way you're going to tackle this.
Ms. Leung.
Michele and I also often travel in the same circles as one of the few female general counsels, and particularly people of color female general counsels in the Fortune 500. And I hate following her in panels because she is so good.
Is there a lawyer here?
But all kidding aside, I've been involved in discussions among general counsels, among law firm partners on this issue of diversity for years, many, many years. And we've never seemed to be able to say we've solved the problem. The problem exists. So coming here tonight, being invited to speak in this panel was an eye-opener because I had no idea that judges were concerned about this issue as well. And to be here tonight and see so many judges who have a genuine interest and a desire to address this issue gives me great hope that among general counsels, law firms, and the judiciary we'll be able to make real progress on this topic. With respect to some of the issues that were raised tonight about, why is there a lack of women taking lead roles in commercial cases, I think, in thinking of that question, I think it's because we have the implicit bias. I think there is an acceptance that we have a notion of what it takes to be successful and to be a good litigator in a tough commercial case. And I think that for many people, implicitly, they think it's what's always worked in the past. So it is a white, older male, great law school, big firm. And I think that to make real progress, we really need to challenge those assumptions that we have about what it takes to be successful. I think back in my own experience, and I am very grateful that in my case, and coming to my current role, our board of directors and our then CEO challenged traditional notions of what it took to be a general counsel of a major pharmaceutical company. If they went by the playbook they always went by historically at the company, I would have not been appointed to my role, because the playbook had always been white, male, over 50, partner in a major law firm, and someone who graduated from Harvard Law School. That was the playbook. And because our board of directors and our CEO didn't look to that same playbook in making the decision to appoint me general counsel, I was able to come to my role. And I think that that's what we all need to do in this room, to really challenge those notions about what it takes to be a successful litigator. What does it take to be successful in a commercial case? And I really do believe that to make real progress, too, we really have to embrace diversity and accept that diversity, and having people of color, having more women represent us in the courtroom really is an advantage. It's a business advantage. It's not just something that we should embrace out of the goodness of our hearts because we think it's the quote-unquote the right thing to do, but we really have to accept and believe that having our companies represented by people of color, before judges, women judges and diverse judges, will make a real difference. And so I wanted to keep my remarks very brief, and I'll pass it to Judge Batts.